evening, hello and welcome. You're watching Plain Speak here on CNN News 18 with me, Poonam Burde. In the recent past, we've heard the clamour and the opposition for a uniform civil code. Even today, it came up in the parliament when Law Minister of the country said, as of now, there is no plan to bring in the uniform civil code. That was what the Law Minister, Kiran Rijiju, informed the Rajya Sabha today. Now, while the debate over edging out personal laws has been raging for a while now, today, an interesting case has come to the fore. In a landmark decision, the Madras High Court declared the Shariat Court's ratification of a unilateral divorce as null and void. The court stated that Muslim women can approach they can get a divorce only via the family court like any other individual in this country. Self-declared private organizations or private bodies such as Shariat councils cannot arbitrate in such matters, and such decisions by any of these entities will be invalid, was the clear word. Now, the court was hearing a case of Khula. The court ruled that while it is open for a Muslim woman to exercise her inalienable right to dissolve the marriage by Khula, it can only be done by approaching a family court. It cannot be done before a self-declared body consisting of a few members of the Jamaat. Now, what is Khula? It is a unilateral move by a Muslim woman to seek divorce from her husband. It can be effected orally and has the effect of an instant divorce. Let me break it down for you and tell you exactly what the Madras High Court order from today said and why it is a matter of discussion. This is what the Madras High Court observed in its order. It said that Shariat councils are neither courts and neither are they arbitrators, which is why they cannot make a decision. The Shariat Council cannot certify the dissolution of marriage by Khula. That's another thing that the court today said. Muslim women can approach only family courts for divorce. You can get a divorce via the Khula method as far as personal laws are concerned, but it has to be ratified, it has to be certified by the family court. Courts have also frowned upon such practices where Shariat councils take such decisions, is what the Madras High Court observed. Now, many would say this verdict opens a Pandora's box. Let me tell you why. There are many implications of such a verdict coming to the fore, and the one big thing is that it sets a precedent of holding the Shariat Council invalid. Any decisions by organizations like these are null and void, is what could be cited as precedent in other cases as well. The other implication is that decisions by Muslim bodies can now be overturned by the law, at least in some parts. There's also equality for both men and women in the eyes of the law. You know what happened with triple talaq. Now, talaq is what gives the right to the man in a Muslim marriage. Khula is what gives the right to a woman to ask for divorce. So while triple talaq is also something that has now been banned by the law, Khula is also something that is open for the judiciary to step in, at least in some aspects, bringing in gender parity as well. Another implication is that it does set a stage for the debate on a need for a uniform law, whether or not personal laws should be edged out. That is also something that could come out as an outcome of this particular verdict that has come to the fore from the Madras High Court. Now, let's be clear. Today's verdict in this particular case does not completely disregard personal laws. They still have a place in this country. But what the court has done today is they drew a line when it comes to certain aspects. And this verdict cannot be looked at in isolation. I say that because in the recent past, especially in 2022, several courts in this country have come out and said that there are laws in this country as part of the constitution which will supersede personal laws. And let me take you through some of those verdicts or observations that have come to the fore in the recent past. Now, in November 2022 is when the Kerala High Court said that Muslim marriages are not excluded from the POCSO Act. Child rights is paramount. The husband liable for sex with minor Muslim wife will be pulled up under the law of the POCSO Act. Kerala High Court in October again said that they will not surrender to the opinions of the Islamic clergy. Again, they were listening, they were hearing a case in which Muslim personal laws was the bedrock of the argument the petitioners were trying to make. In October, the Karnataka High Court held pregnant Muslim minor's marriage invalid because she was a minor. It was the child's right that was paramount. Back in 2015, there was a Gujarat High Court observation as well, which said that prohibition of Child Marriage Act to prevail over personal laws. The special act will override provisions of the Muslim personal law in case of any other religion, as it is in the Hindu Marriage Act or any other personal law. So it is the POCSO Act as far as child rights are concerned. But with the Madras High Court yet again now stepping in and saying that Shariat councils cannot be arbitrators, cannot be courts in this country, has that now set up the debate of whether or not it is time for the judiciary to supersede Sharia. Let me open this right up. Women's rights activist Zakia Soman joins us on this broadcast. Editor of Law Beat, Sania Talwar, is with me. Advocate at the Madras High Court, Ramaswamy Mayappan, also joins us. Advocate and leader of the United Muslim Front, Shahid Ali, also is with us on this broadcast. And so is advocate and political analyst Tausif Ahmed Khan. But I'd like to begin by asking Ramaswamy Mayappan, how do you read the order that has come to the fore from the Madras High Court today?
See, I will keep it simple. Just two things to start with. One, the court has taken the grounds that the Shariat Council, a body under the Tamil Nadu Society Registration Act, is not a body legal that does not have the sanctity to grant divorce to an individual, and that right is only with the family court. That's one. Two is they've also gone into the issue when there is a distinction between Section 2 and Section 5 of the Central Act and the State Act and the Shariat law. Then what law would prevail and how should that amendment be read? And they've read that amendment in favor of the man in this particular case. And they said that way equality will prevail between the two genders and they'll be able to seek their appropriate remedies, either the Talaki, Taviz, Khula or Mubarak or the first. Then that right appropriately can be sought by the wife only through the family court. That's where we stand today.
Sure. So does this open a Pandora's box? Is there larger implications that this particular order can have?
This does reopen the subject of discussion on personal laws like you started with. So I won't say Pandora's box. Pandora's box has a negative implication. I think today we are in a time of personal laws being protected. And when personal laws and personal rights being protected is being discussed, I think people will have to have equal rights, be it man, woman, any other gender, or even subject to orientation. And I think people have grown past the place where we discriminated against each other, where we had very limited understanding. Today, our levels of understanding are growing. So that progress will have to take place. So I think the first step the courts have taken is that understanding that man or woman, the reasoning that they have to break their union or to be in union will have to be equal. One cannot have a right that the other does enjoy specifically. That's one. And two, that they want to ensure today is that personal laws are protected through a legal forum and not through an unlawful institution or an institution that may not go through the judicial process improper. So the court, in fact, relies on a particular judgment that came out in 2017 and one that came out in 1967 with regards to fatwas, the legalities of fatwas and the legalities of other orders passed by such institutions that do not have any legal basis to pass such orders.
Sure. So, Sania Talwar, I would like to get you in as well. And we've been discussing personal laws for a long time now, especially in the recent past, the clamour for a uniform civil code. So, even if we're far away from that, even as the law minister said that today, as far as trying to get into the debate of personal laws is concerned, or at least in certain aspects of it, there is some sort of unity that there's some sort of uniformity that seems to be being brought by certain courts of this country as well. Like I mentioned, a few hearings that have happened in the recent past.
Absolutely, Poonam. I'm no scholar on personal laws as such, but there are lots of judgments which are now coming up. This one in particular that you're talking about, so far as the Khula issue is concerned, about all these extrajudicial forums coming up and announcing their own verdicts. So that is being taken note of, and it's a great thing. Apart from that, we must also remember that there is extrajudicial, so as to speak, or a separate parallel system of people or bodies that tend to claim rights of specific communities or specific groups of people. Very recently, the All India Personal Law Board had said that even though the judgment on Khula, which was back in November 2022, had said that it is an absolute right of a Muslim woman to claim Khula by a judicial forum, the husband can come and say that it will not be so. And they can contest it. So, this is something that we should deliberate on, and these things can only be done by the UCC. I'm pretty sure of that. But let's see where it goes.
Sure. So is this one step towards moving towards the UCC? We've seen the clamour. We've seen the kind of comments that have come to the fore from this government as well. Even now, the government has been maintaining that the Law Commission, which will be constituted, that is what will look into it. And we're in no hurry to bring such a law. We will also make sure that we take all of the stakeholders on board before any such decision is made. But Tausif Ahmad Khan, as we see these hearings happen and as we see these verdicts come out of specific courts, in instance what happened today in the Madras High Court, do you think this is a case of a one-off incident in isolation, or do you think it will have larger ramifications as far as it being cited as precedent in some cases?
No, you see, every case is different and every case outcome depends on the facts of the case. So when in this particular case that you're talking about, where Madras High Court has delivered its judgment, the Sharia Council relied upon a judgment of a Kerala High Court. In the Kerala High Court judgment, the court upheld the right of a woman to approach extrajudicial forum for declaration of the dissolution of the marriage. And in this Madras High Court judgment, they have said that no, in this particular case, this is not a fit case, you must approach the family court. And in both the High Court judgments, they have relied upon the Muslim Personal Law Sharia Application Act, as well as Dissolution of Muslim Marriages Act. You see, so there is no, after this judgment, there is no such thing as if, opening of a Pandora box or any drastic change is going to happen, or if this sets a path for, implementation of UCC. No such thing is going to happen. Only, depending on the case, the law, the existing law, which is there, which is the Muslim Personal Law Sharia Application Act, it is interpreted according to the case and, according to the facts, and the judgments are delivered.
Sure, but the ratification has to be done by a court and not like bodies, not by bodies like the Shariat Council, is what the court said today. And don't you think that would, in some case, bring a sort of uniformity in the sense that if a marriage has to be ratified for any other religion in this country, or divorce has to be ratified, we have to go to a family court, which is exactly what the Madras High Court has asked the couple in this case as well to do.
No, you see, the act of giving divorce, the act of pronouncing divorce does not need to happen inside the court premises, inside the family court premises. No, that is not the case, and the court has never said that. The requirement for pronouncing talaq or for pronouncing or asking for khula talaq is there are some ingredients, like there has to be witnesses, and you have to be in your sound mind. And there are other technicalities and qualifications involved.
Sure.
But that never requires a woman to approach the family court itself. I mean, the process can be initiated and the process can be completed, but it can always be challenged by the husband. Like in this case, the woman sought the divorce and she got the divorce, but the husband challenged it. And the court, considering the fact of the case, has rejected, said that no, you go before the family court. So therefore, it all depends on the case to case. It all depends on the facts and whether all the prerequisites, which is there in the Shariat law, has been followed or not.
Sure. But Zakia Soman, there are many within the community also who believe that, especially after the ban on triple talaq, there are several husbands who would want a divorce from their wife are now trying to pressurize them into following this particular path because it is easier to get done. And when we have parallel bodies like the Shariat Council intervene and ratify these kind of decisions, then many believe that there are reasons for the woman to be the aggrieved party in certain cases.
Yeah, so you're right, Poonam. It is about justice for both parties, and all the more about justice for the vulnerable party, which 9 out of 10 cases it happens to be the woman. So the Muslim woman's right to access justice, just like all other women, Hindu women, Christian women, Parsi women. So Muslim woman also requires a similar right at similar footing. Right to khula is a right granted to her in religion, but in reality, the practice of this right is very, very difficult. A lot of impediments are put in the way of khula, and invariably, a lot of conditions are put in front of her, which she is not able to fulfill. So in this instance, where the Madras High Court has said that they should approach the family court, I'm not particularly aware about the specifics of this particular case, but in general terms, khula is a right given. It's an affirmative right given to the woman who can initiate and seek divorce of her own volition.
Sure.
So what this observation does is kind of, it is highlighting the need for accountability in the community mechanism. So Shariat Council is one community mechanism. There are caste panchayats also across the country. They go by various names.
Yes.
But the problem arises when they do justice in a very arbitrary manner, and very often they do justice, which is only beneficial to the male party and not so much to the woman's side. So accountability is necessary, because you look at it from religious point of view, or you look at it from constitutional point of view. Both woman and man are entitled to justice and equality.
Yes.
And as was said by the panelist, equality is the prime concern here, that both parties should have that opportunity for justice and for equality. So I look at this observation as a step forward.
Sure.
But without being aware of the specifics of the case, Poonam.
Sure, Shahid Ali, it is about accountability, irrespective of the religion. Unfortunately, we live in a patriarchal society. There are certain sections in every religion which are male-dominated, which would want to give the benefit of the doubt to the man. Unfortunately, we live in those times. When we are talking about accountability as far as personal laws are concerned, many even within the minority community, within the Muslim community, would believe that there is no accountability to organizations like the Shariat Council, and in more often than not, in most cases, the man would get the upper hand. So by sending the woman to the family courts, to a uniform system of judiciary that is applicable to every citizen in the country, we are trying to bring in that uniformity, at least in one sort of, in one particular section of the personal laws. Do you agree?
Yes, it is true. And this has been
in fact, you please appreciate one thing only. The question is to me. I think I
yes,
should
Shahid
reply
Ali,
to
go.
that.
Yes, Shahid Ali, go ahead.
Yes. We should appreciate one thing only, that there is Sharia Act 1937, and Sharia Act provides what? That any person, those who are Muslims, I mean to say the both husband and wife should be Muslim, they may declare that they are Muslims and they want to get their dispute resolved. Disputes as regards maintenance, as regards inheritance, as regards marriages, as regards adoption and everything, the will and all. That they may confer this power to or upon anyone, and thereafter they may approach that authority to get their dispute resolved. This is absolutely in consonance with Constitution of India. This is in consonance with Sharia Act 1937, which has also been passed by the Parliament, and this is being followed till date. So any order in contradiction to that Sharia Act or violating the Sharia Act is absolutely illegal. I think this order passed by Madras High Court is illegal, and this should be approached. This should be challenge before the Honorable Supreme Court, because in one or this other sense, this order violates the Sharia Act 1937 and also the Constitution of India. Constitution of India empowers all citizens of India, whether they are Hindu, Muslim, Sikh or Isai, to follow their own religion, to follow
yes,
their...
and the Madras High Court, even in this particular case, Shahid Ali has made it clear that the woman under the Sharia law, under personal laws, does have the right to seek unilateral divorce
absolutely
or instant
not.
divorce.
What is... No, absolutely not. What is Khula? Khula is the mutual consent divorce.
But it's initiated by the woman, isn't it?
Go through all rigors of approaching the court. Thereafter, this the matter delayed in court. Matter is dragged in court for several years. Therein, the provision is that they may approach a particular authority by way of moving appropriate application with that authority to seek divorce by mutual consent. What is bad in that?
But isn't that how divorces?
Absolutely not.
Isn't that how
And that
divorces are ratified across the
also.
country for every other religion as well? Even marriages, for that matter, a Hindu couple would get married in a temple, for example, and have the priest sign on it and have a certificate. We still would have to go to court and get a certificate, isn't it, from the judiciary of this country?
Rectification will come only if there is any irregularity or illegality. There is no such irregularity, illegality. Please tell us one. What is irregularity? How the women are oppressed? Even the women are empowered by virtue of that act to approach that authority to take mutual consent divorce. Now you want every woman that they should run to the honorable courts and to drag in honorable courts for years.
But would you deny the fact, Shahid Ali, that many within the community also have raised the fact that...
You should appreciate it, and I say, I say from your channel that we all Indians should approach that kind of approach.
Sure. But I just want to ask you that, like you say, that this is going to get caught up in litigation. But it is about having that particular faith in the judiciary of this country, isn't it? It is the same courts that you knock on the door of every single time you are the aggrieved party. So when ratification has to happen, a certification has to happen of marriage by the court, then why not divorce?
Parliament. Ms. Poonam, please try to understand one thing. This act has been passed by the Parliament. So this is not contradiction.
There
this
was
is
no
not
Parliament
in contrast to
1937,
the judiciary or the dictum of judiciary. This is absolutely in consonance with that.
Would you also deny, Shahid Ali, that the Waqf board across the country has warned several elements within the community to not hurry these khula requests, because there have been instances where the husband has been trying to pressurize the wife to use this approach for a divorce because triple talaq has now been banned? Have those kind of advisories and warnings not come from within the community? If that is the case, then why shouldn't the courts of this country take a view that caution is better?
That's why I'm saying if pressures are mounted, then they may file a complaint. If pressures are mounted, they may file a complaint. Honorable courts are there. The law enforcing agencies are there. If such incident comes that the pressure has been exercised, then absolutely. See, what Sharia says, that the consent should be free consent. Absolutely, in terms of Section 10 of Contract Act, both the parties should be major and the consent should be free consent. Consent should be out of their own volition. Consent should not be actuated by fraud, coercion. So, if any consent has been obtained by fraud, coercion, then the courts of criminal law are always open.
Sure. But we should not take precautions. We should wait for something to actually go wrong before approaching the court. That's the approach that Shahid Ali would like to take. Is that the kind of approach that we should be taking?
How you can apprehend something? So
but don't you think that prevention is better than cure, which is exactly why the court in this particular case has said get it ratified, and whichever party is...
If you will go through entire IPC, accepting the dakati, no offence, at the stage of preparation is a crime.
Sure, so this is completely invalid and illegal is what Shahid Ali says. Tausif Ahmed Khan, do you agree?
No, you see, he does make sense. You see, nowhere does the law forbid any Muslim woman to approach the court. It is open to them. Similarly, it is open to them to approach the Shariat Council. If there are Shariat Council, they have a purpose. Now, the law does not require, does not take away the right of the woman, to initiate the khula process only through the family court. That is not the law. If today government wants to make amendment and only says that, okay, no, you even under the application of Muslim Shariat law, you will have to go to the court only to file a divorce petition like anybody else, then that's taking away the personal law. And this judgment does not say so. You see, this is this particular case where the court was considering a fact of divorce already pronounced by the wife, claimed to have, obtained the divorce, which was disputed by the husband. So by looking at this case, the court has ruled, High Court has ruled that no, you must approach family court. So it is applicable to this cause. Whether this becomes a precedent and whether, everyone else starts contending that you have to go to family court to obtain a divorce, then that's a bad law. But the law does not say so. Under the Muslim application of Muslim Shariat Act, it means that you can, the basic requirement which is there is not of the court. The requirement there is of being in sound mind, and the requirement there is of the witnesses, and there are some requirements which should be fulfilled if you want to pronounce a valid divorce. Whether this divorce is valid or not, that may be challenged, and for that court maybe may look into it. And so far the Shariat Council is concerned, fatwa was never. No one claimed that fatwa is a legally enforceable opinion. Fatwa is an opinion. People can approach council, approach a mufti and obtain a fatwa. It is never legally enforceable. It depends upon the parties. If they accept it, very good. If they do not accept it, they may go and challenge and open up the litigation. Once you go, even today the government and the courts discourages people from coming to court. What are you saying? Court says that you try arbitration.
So the order that came to the fore from the Madras High Court today could have implications that it shouldn't have. It could set the wrong precedent as well. Is that what you're trying to say, Mr. Khan?
Depending upon people, if someone contends that no divorce has to be obtained under Shariat law only from the family court, then that's a wrong contention. And that rely upon the Madras High Court judgment, then that's a bad law. It has to be challenged and then it will be set aside, I'm sure, if the matter reaches to the higher court. And why to a higher court? Look at the Kerala High Court. Kerala High Court judgment is there. I'm sure there are other High Court judgment as well on this point. Because the law does not require a Muslim woman in order to obtain the Khula to approach family court. Sure,
so by putting that particular caveat in this particular case, right? So by putting that particular caveat in this case or in this particular order that the Madras High Court has come out with, there is some sort of meddling as far as personal laws are concerned. Ramaswamy Mayappan, that's one of the allegations that's being made. How do you respond?
Poonam, no. The court has actually been very categorical, and I think people have inferred the wrong thing from the Kerala High Court judgment also. The Kerala High Court categorically states, one, that the Muslim woman has an inalienable right. And in that particular case, the Khula was not treated properly. That's the reason the woman went to the court and actually sought. And the court gave three different options. Said either a declaration of repudiation or termination of the marriage, an offer to return the dower, and an effective attempt for reconciliation will have to be taken up by the Khula, which the institutions failed to do. Which again here in this particular case, when the petitioner, the husband, attempted to go and ask for restitution of conjugal rights without taking proper reference to the entire matter, the matter was dismissed. The matter was dismissed ex parte, and that's the reason the husband approached the court. And this is why the courts in this particular case found that the Shariat Council is not a body that can go through such arbitrations or dispute resolution, and the court may be the appropriate forum where for dissolution of marriage by Khula, people will have to obtain certificates only through the court, particularly the family court, rather than the uncertified institutions where only members of Jamaat sit through and do not follow strict procedure.
Sure, Zakir Soman, is uniformity all that bad? Yes, personal laws, there are several of them which, especially for the Muslim community, are very, very different as far as marriage goes, marriageable age goes, as far as adoption or divorce would go. In certain aspects at least, perhaps not a blanket uniform civil code, but in certain aspects at least, getting in uniformity for all sections of all religions in this country, would that be such a bad thing?
So Poonam, uniformity in itself is not the goal. When we say uniformity, we are saying it as a means to the end goal, which is gender justice. So because of all these different kind of personal laws and different kind of practices, the end result is that justice is not done and the rights of the woman get violated. That's the concern. So the central theme here is justice for the weaker party, which in 99% cases in a country like India happens to be the woman. So that's why, to address the anomalies and the loopholes and the gaps, because the way, the gentleman said that Shariat Application Act is passed by the parliament. I am sorry, there was no parliament in 1937. This is a law of the British era. And this law is highly incomplete, not at all comprehensive. It is insufficient.
Almost all laws are of British era.
To give legal protection
Those
to
laws
women
have been adopted by
in
Parliament.
all the important matters pertaining to marriage and divorce, beginning with age of marriage, beginning with the procedure of divorce, beginning with the question of polygamy, the question of custody and guardianship of children, the Quran given rights of share in property. None of these are included in a codified manner in the so-called Shariat law under which we are governed. And as a result, this whole unequal situation has been created in reality, where the Muslim woman is on the receiving end, and she invariably never gets justice. And that's why this whole hullabaloo over the loopholes in the personal laws as found in practice, coupled with these community-based mechanisms, I agree with the point that they have their validity, because legal justice in our country is costly, it is time consuming, it is complex, complicated, all that is true. And community institutions are serving a purpose, provided they are made accountable, provided there are the principles enshrined in the constitution which are not violated in the name of personal laws, and they have to ensure that justice is done. So this whole effort is about bringing accountability, and making the environment more affirmative, more conducive for the weaker party, which unfortunately in our country happens to be the woman.
Yes.
So uniformity is also referred to in that context, Poonam, so that the anomalies, which are found within all these different practices are kind of eradicated.
Sure. So how do we get rid of those anomalies, Sania Talwar? Many would believe that UCC is the way forward. The government also has been speaking of it. But unfortunately, that's all that has happened. All we've heard is the government speaking about it and it coming up every single time in a span of a few months. But since 2016, since when the government went on and said that we'll begin consultations, we'll try and get into the process, to now 2023, there's very little that has been done. The government keeps saying that the Law Commission will come into effect and they will look into it and then we'll see where we go about that.
Poonam, I'd like to also point out one thing. Since the Constitution was mentioned and rights of religion were mentioned, it is also important to remember that Article 14 also exists, 15 also exists. So if there is a right to practice and profess religion, there is a right to equality also. This contradiction in itself is what was the problematic issue that started in 1954 when the Hindu Code came in and nothing was done about the other communities. Other communities, and especially women from other communities and the Muslim women, were kept in the limbo. And it is unfortunate that it's not been done for so long. Uniform civil code, whether or not it will come into force and when it will come into force. Of course, these are deliberations and they're going on. And I think it's a massive exercise. A lot of communities, their sensitive aspects and the issues that they want to take note of and they want to make sure are put in place, they have to be debated on, and it takes a long time to do that. And I'm glad that it's being deliberated and debated before it's actually being effectuated and passed. But how to get rid of these anomalies, I think that seems to be the right way forward. And when we're looking at religion, we also have to look at equality. So these two things from the Constitution have to run side by side.
Absolutely. So equality, accountability, the freedom that the Constitution guarantees to every single citizen, it should be applied to every single citizen. And that's really the message that perhaps comes out. Whether or not it is time the judiciary in this country supersedes is paramount to anything else, be it personal laws or organizations like the Shariat Council. Well, the jury is out on that, and I'd like to thank all my panelists for joining us here on this broadcast with your perspective. We're shifting focus now to the temple town of Ayodhya, where the Grand Ram Temple will be opening its doors to devotees in January next year, and the construction is all on track. 2 Shaligram stones were dispatched from Nepal for the Ram Temple. They've reached Ayodhya after covering a distance of over 500 kilometers. They're considered to be centuries old by the faithfuls. These stones are likely to be used for carving out the idols of Ram Lalla and goddess Sita for the Ram Janmabhoomi Temple. What will be their exact purpose, we don't know yet. But what we do know is for sure is that the significance these particular stones hold for devotees who thronged Ayodhya in large numbers to pray this morning. The stone is considered to be a representation of Lord Vishnu. It's seen as a sacred object. Shaligram stone is used in several Hindu rituals. It's believed to bring good luck, prosperity and blessings to those who worship it, which is why we saw the temple town of Ayodhya all decked up for the arrival of this Ram avatar. CNN News 18 was on ground there to soak it all in. Take a look at the special report.
The Ram Temple construction in Ayodhya is going on in full swing. Two sacred rocks from Nepal have arrived in the temple town. The idols of Ram and Sita will be carved out of these rocks and placed in the main temple complex of the Ram Mandir. The stones have been offered for the Ram Lalla idol by the people of Nepal. The Shaligram stones are said to be found only on the river banks of the Kali Gandaki river that flows in neighbouring Nepal.
As the construction of the Grand Ram Temple gains pace in Ayodhya, these are the two huge several tons of Shaligram rocks that have now arrived in Ayodhya all along the way when they started their journey from Nepal and all along their way to Bihar and then parts of Uttar Pradesh, Gorakhpur especially in Uttar Pradesh. They have seen a lot of crowd turnover. People have been, getting close to these rocks to get a glimpse of them, touch them, and in fact they have been treated with a lot of religious fervor, a lot of reverence by the devotees here.
One stone weighs 18 tons and another 16 tons. Both of them have been approved technically and scientifically for making the idol.
क्या है इन पत्थरों का महत्व क्या है?
ये गंडकी वो जो गंडकी को बोलते हैं कि ओल्डर देन हिमालय. इंडेक्स फॉसिल टेक्टोनिक अपलिफ्ट ऑफ हिमालय का इंडेक्स फॉसिल्स शालिग्राम शिला है. वो अमोनाइट वो होता है. ये कैल्साइट है, वो क्वार्टजाइट है. ये साक्षी बैठा है कि ये इसका प्रमाण शालिग्राम है, वहाँ मिलता है.
Hundreds of volunteers and devotees went to Ayodhya to welcome the sacred stones.
इस पत्थर को हम लोग भगवान विष्णु के रूप में देखते हैं, जो शालिग्राम जिस जगह शालिग्राम रहता है उसी जगह पर यह पत्थर रहता है, तो इस पत्थर को भी शालिग्राम के ही माना जाता है.
काली गंडकी में शालिग्राम मतलब वहाँ पे मानता है नेपाल में, जो काली गंडकी की जो पत्थर सब है बिना काटे हुए तो मूर्ति का रूप तो नहीं होगा, वो तो करना ही पड़ेगा.
अब यहाँ श्री राम अवध में यहाँ पर मंदिर में सजे बने, और यही हम लोग की कामना है. बड़ी उल्लास के साथ हम लोग आए हैं, सैकड़ों की संख्या में जनकपुर धाम में.
The grand celebrations for the opening of the Ram Mandir will start in December 2023 and will continue till Makar Sankranti in January 2024. The door of the Grand Temple will be opened for devotees on the 1st of January 2024.
But that is time for a quick break here on this edition of Plain Speak. But on the other side, we have a super exclusive interaction with none other than Sania Mirza. Do stay tuned for that.